Yeah. 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 Well, you already know what time it is. You already know what time it is. It is time for us to go ahead and look at the full trends. I'm gonna drop myself down here. So I want us to get this whole thing up and at 'em. I'm your boy Tay Biz TV, and I have the full 56-page transcript of the secret, the infamous secret ex parte meeting. Now look here. We already know what happened on June 10th. Some miraculous reason Woody wanted to testify, right? But there was an odd, strange thing that happened where they were called into court for a 9:00, 9:30 start, and they didn't get started until after 11:30. Everybody, including the defense, was like, "I don't understand what's going on. What is this?" Right? That's because there was a secret meeting that happened on June 10th, and no one knew what this secret meeting was about or whatever. But Brian Steele, aka YSL Steele, stepped up to the plate, said, "Hey man, I heard y'all had a little meeting, man." He said it like Terrence Howard. "Hey man, I heard you had a secret meeting, man." Right? And he actually mentioned some things that was given to him in this particular meeting, and he presented it to the court. And what happened? We all know Glanville held him in contempt, criminal contempt at that. But today, as I sip this beautiful bourbon, I am going to read. We are going to deep dive into what was said, what was happening, who was there, who said what, did what, when, what, how, what, right? So before we even get started, real quick, I got a question. If you feel like, not just think, but if you feel like this is not a fully unredacted transcript, go ahead and hit the like button. Even if you just feel it, right? Because it took you from June 10th all the way to here it is. Here's the date, July the 1st, to give us the quote unquote unredacted full transcript. I mean, 9 more days, it would have been a month, sir. So at 7:45 p.m., court was in recess that day at about what? 2, 3? He was really. If this is if you feel like this is the fully unredacted version, go ahead and subscribe to the channel. If you feel like it's a little bit doctored already before we get into this, go ahead and hit the like button. All right. Or you can hit both the like button and the subscribe button. But here we go. All right. Let's get into this. It's going to be a little bit. It's a doozy. Now it's 56 pages. Okay. So we actually going to get into the actual conversation that was taking place. And this is presented to us by the court reporter, Christina Weaver. Let's go. In the Superior Court of the Fulton County, state of Georgia, this is case. Here's the case number here. Here are all the defendants: Young Thug, Shannon Stillwell, Rodalius Ryan, Quamarvius Nichols, DeMonte Kendrick. I mean, these are some names now. Marquavius Huey. I mean, these are some names, okay? Transcript of the ex parte hearing in the chambers of the Honorable Ural D. Glanville on June 10th, 2024. Christina Weaver, who is the court reporter of this transcript, is the one that's presenting this. The appearance of counsel: Adrian Love, Simone Hilton are the ADAs. And then you have on behalf of Woody, Kenneth Copeland, Kayla Bumpus. Remember, she is the one that is no longer need to come to the hearing. The hearing has been canceled. Everything about Kayla is good now. She is in Houston, at home, chilling. She don't have to come back to Atlanta no more. All right. It says here that the ex parte hearing began at 9:10 a.m. Present in the chambers were, this is the initial presence of the people in the chambers: Glanville, Adrian Love, Bumpus, the court reporter, and the investigators Antonio Long and Rashid Hamilton. Okay. Notice Simone Hilton is not there yet. Notice that Woody is not there yet. All right, keep that in mind. Court reporter says, okay, I'm ready when you are. Ms. Love, thank you. The concern that we wanted to bring to the court's attention at the state was twofold. One, we wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces. And we want to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him in the court when the jury came out. The second concern that I have is I wanted to bring to the court's attention in line with the concern that I expressed on the record on Friday. I don't know what advice counsel may have offered or may be offering. That is their right and their business. As it relates to testifying, however, I do not believe that criminal exposure is a concern which is interesting in being spoken about and protected, which is interest in being spoken about and protected. Mr. Melnick relayed to Ms. Hilton on Friday that he never heard of the statute 245507. And on Friday, he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Sharp. I don't know if he unintentionally put my name on it. But he sent an email to Mr. Steele and to Mr. Sharp with me and Simone copied where he said, this is the communication that I received from Miss Love regarding Mr. Copeland. My response was, whose interests are you protecting, yours or Mr. Steele's? Whose clients? Which client are you protecting? Whose client? Yours or Mr. Steele's? And Mr. Shards? He wrote back, said, you are going to get him killed. You have made him, you are making him a target. You is what he wrote in the email. Okay. Now, I want you to keep in mind this part right here. Whose interests are you protecting? Mr. Steele, Mr. Shards, or whoever, the client, whose client? Keep all this in mind, all right? He said, F you, man. So given that his concern is that by testifying, at least the one that he conveyed to me in writing, it's not his concern has nothing to do with the exposure from the state. And if his concern, the court, his being whose concern, Mr. Melnick, if the interest that he is protecting is Mr. Copeland's freedom, he did not convey it by asking us what exposure does he face in testifying. In fact, if he's concerned that testifying will get Mr. Copeland killed and he is not communicating with us, he's communicating with counsel for defendants. It would seem that he knows a thing or something that we don't know. Additionally, I will let Ms. Bumpus tell you, he has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if your interest is your client, then it would seem you would want to be there for him while he is testifying. Well, he is on vacation this week, the court says. Ms. Love, I understand. That is why he has Ms. Bumpus here. And he has said what he has said. And I was reading the statute, the thing that is, and I was reading statute about this particular situation. And I was reading our rules, our ethics rules of conduct for attorneys. And it is clear that if an attorney, there were two things that were happening. One, Mr. Melnick had told me that he wasn't Mr. Copeland's lawyer. Mr. Copeland had told Ms. Hilton that Mr. Melnick wasn't representing him. And then rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Sharp, and Mr. Melnick reaches out to Mr. Copeland and injects himself in these proceedings. Now, they're saying that Woody said he never had a lawyer, all this kind of stuff. But the fact of the matter is he did not say that, but we're going to get into it. All right. What we were discussing was in no way a matter that Mr. Melnick was representing Mr. Copeland on. And that is where we are not allowed to speak with the person when they are represented by counsel. Mr. Melnick could not have been representing Mr. Copeland on anything when we went on anything we were talking about, because we were talking about this case in this trial. All that aside, we would like an opportunity for the court to address Mr. Copeland. With Mr. Copeland stand in counsel present, Ms. Bumpus is looking at me like, I'm listening. That's what Ms. Bumpus said, I'm listening. You know, Ms. Love said, with this stand in counsel present, and to allow Ms. Bumpus an opportunity to explain Mr. Copeland everything that I have just said. Her concern outside was what is the longest he can stay in jail. What I relayed to her is that the statute says until he purges the court by testifying. This, and when you see the court, that's Judge Glanville, okay? Ms. Love, his contempt by testifying. Court, yeah, 507 is a little different. It's a little bit different. So, I mean, you know, Ms. Bumper's like, so until the end of this? Like, what you mean? The court is like, he could be here until the end of the trial. Here as in jail. Or, you know, here. And again, you know, if he's not testifying, they're talking about to the end of the trial, he'll be in jail. Ms. Bumpers, this is what I said. To the end of trial is the longest. Ms. Love said, no, it's not the longest. Even after a grand jury, if a person has been subpoenaed to testify before the grand jury, and even after the grand jury has, what is it convened, has left, that person can stay until the person purges himself of contempt by testifying. The statute literally says that. Ms. Bumpers, well, I'm going to look it up because it was my understanding that it was until the end of trial. So if you look at this, Ms. Bumpers is talking to them as if Woody already decided to go to jail. Wow. Okay. This is interesting, guys. This is very, very interesting. Go ahead and hit that like button, man. Hit that like button real quick. I'm giving you all some inside information. All right. Yo, that's wild. Okay. Here we go. Where we leave off at. All right. So she said, nope. Here it is. Literally the words of the statutes. And so court says, and they intervene and says, he could be in there a while. Let's put it that way. Either way, cut him off. I just want to be able to give him, I know. And Glanville will cut you off. That's he said, I know. It's kind of the statute says, you know, that you purge, but I can't keep him in there indefinitely. I've got to kind of, right. This is all I want to know. The court says, you know, the whole thing is that he can, and he has the keys to his own freedom. I mean, and that freedom is if he just gives his testimony, then he's purged it. His Bumpers, right. Love, yeah. And, you know, whatever that testimony is, we know what we believe it to be, but, you know, we don't know what it is. We can't talk about it. We don't know. We don't know what he's going to say. We have an idea. We know what he's told us. Ms. Love, okay. And our concern is that our concern, I know the court said essentially you intimated that Mr. Melnick probably told him essentially you should testify. They can't do anything with your testimony. But what we overheard being said was they are going to hammer you, as if we were going to expose Mr. Copeland to you. You heard that? Ms. Love, yes, yeah. Mr. Melnick told Mr. Copeland we're going to hammer him. The court, now, to be fair, I think Ms. Bumpers, as an advocate, or anybody has got to tell him he's going to face some pretty significant cross-examination. Now look at the judge. Judge Glanville is so. Oh my God, we what? Oh my goodness, oh my goodness, this is insane, man. Now to be fair, yeah, right, yeah, I think that's what he meant. I mean, he's going to face. He's got about 10. So he meant the defense is going to hammer him. That's what Ms. Love said. Ms. Bumpus, no, just in general, he's going to be. It's not. It's not going to be a hey da 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 da. Ms. Love, he knew that. He already been expressing that. So the court says Glanville. But I mean, I think that if he's concerned about that, well, but it's all in the message, in the packaging, in terms of, I think Mr. Copeland is, a savvy person. But he's certainly going to be subject to a thorough and sifting cross-examination. Ms. Love. And the other thing is that can I just say something in Attorney Melnick's defense in response, just for the record? Ms. Love, yes? Okay. Ms. Bumpus, here we go. The reason that he doesn't want to move forward with representation, what I have been told, if he decides to testify, is that he doesn't feel like he can. He doesn't know what was said outside of his presence. So he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. Remember, the state talked to Woody without representation. And the time that the state talked to Woody, Mr. Melnick was Woody's attorney. He was Woody's attorney. So this is the reason why Mr. Melnick said he wanted to withdraw if he testifies, because that's called a noisy withdrawal. Go ahead and look up noisy withdrawal in legal terms, and you'll see why he wanted to withdraw. Let's proceed. Ms. Love. But the thing is that the only thing that he should be concerned about is the criminal exposure, or the exposure that Kenneth Copeland has criminally. And there is nothing. There is literally nothing. The statute is quite clear that we can do to him about, the only thing that we would put him in harm's way is a lie and a refusal to testify after being ordered to do so by the court. And by a lie, we don't mean like, oh, I think you lying. It would have to be, something obvious, because we can always impeach. But if he literally perjures himself, that's something different. We can't help that. We can't control that. We would only say, tell the truth. I don't care how bad it is, just tell the truth. So, like he says, I didn't go down to the police station. Okay, the court says Glanville, and I think part of his challenge, Ms. Bumpus, may be that you need to assure him, look, I'm going to be here, and if you think that they are asking you a question, they, being the state or the defense, is asking you a question that's going to bring out other crimes, that you're going to, he's going to be able to look to you and say, can I have a chance to talk with you? Ms. Love, that's exactly right. Ms. Bumpus, See, Ms. Love, but that's just it. Ms. Bumpus, no, he's not. Ms. Love, hold on. That's just it, Judge. The problem is that there's been an assertion that people are representing, and I'm not talking about you. Ms. Bumpus, like, yeah. There's been an assertion that people are representing that their biggest concern is his best interest, and then they are just not here. And Ms. Bumpus is saying she's not in a position to do that. Look at how she's twisting this, man. Ms. Love is a master manipulator, man. Wow, this is crazy. Ms. Bumpus, no, I'm not saying I'm not in a position. I'm saying that the agreement between Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm to get him to sign this paper that says that then discharges Melnick as his rep. That's their agreement. I can't do anything about that or nothing about that. Ms. Love, that sounds weird. Now, Miss Bumpers already said the reason why Melnick would withdraw from representing Woody, because he don't know what the state told him outside his presence. That sounds weird. That doesn't sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I'm not going to represent you. I don't even know what to do with that. Miss Bumpers, well, he said he does not know what was said. Miss Love, it doesn't matter what was said. Miss Bumpers, right. Miss Love, it doesn't matter. And he didn't ask us. He didn't even inquire. What have you all talked about? He has been talking to Brian Steele and Max Sharp. That's it. He is not talking to us. And in fact, Mr. Copeland, when he was asked to speak with us, Mr. Melnick barges in, gets in between me and Miss Hilton and Copeland, and literally keeps us from talking to him before he gets called to the stand. And that's troubling. Remember now, that Friday, he said to the court that Woody was going to invoke his Fifth Amendment right. He said he was going to invoke it. They put him on the stand anyway. Ain't that right? Okay. Now they're trying to act like they don't know that. Well, I think what Ms. Bumpers, I think what happened was, and I say this because I previously represented Mr. Copeland previously on his other stuff. So I know when he, this is just what I think happened. I think how Attorney Melnick came involved was his representation of other, because he took my place. Copeland fired me and hired Melnick. And then this came about. And I think so at the beginning, Melnick was representing him. And then in his criminal matter that he had, but that's resolved. Bumpers. But when this case started, Melnick called me and told me that he was representing him as a witness at the beginning. I can assert that. Love, Melnick has never in life, this is 2 years ago. This is 2 years ago, Ms. Bumper says. Love, Melnick didn't, as a matter of fact, less than 2 years ago, when Copeland was sitting in jail for something else he had done, Melnick said, I don't represent him. He told me, now this is all hearsay now, okay? This is all hearsay. He told me I don't represent him. And people were in the room. He was on speaker. He told me he didn't represent him. Now he ultimately did come back or come about and represent him. But when we were trying to get, I guess, Bumper said something, yeah. And Miss Love, Copeland was like, he's not my lawyer. I don't have a lawyer. He's not my lawyer. And then Bumper's like, are you talking about recently? Ms. Love, so recently, Copeland said that Melnick was not his lawyer, right? Ms. Love, okay. When Copeland was in jail, Melnick told me he wasn't his lawyer. But our understanding was that Melnick was his lawyer for those criminal charges. And so the person that came in and argued, or at least stood in for him on his bond, and then on his subsequent plea, was Melnick. But I don't know whose interest he would be representing when he's not talking to us about what we've spoken to Copeland about. He could ask us and we would tell him, So I don't know why he would withdraw his representation of him. If his interest is Kenneth Copeland, then why would you pull out? The court, that doesn't make sense. Love, at the point where he could face the most peril, if that is his concern. If his concern is, I don't know what they talked about, so I don't know what, the court, Glanville. And I thought that Miss Hilton had a list of questions for Mr. Copeland anyway. Miss Love, she did. Copeland, well, how come you all can't? He didn't ask, Miss Love says. He didn't ask to see those. He didn't. And not only that, well, can't you all share that with Miss Bumpus? The court says. Miss Love, how many y'all think, I'm sorry, I just cut myself off. How many of y'all think that this is a doctored transcript? This don't even what is going on right now, man? What is going on right now? You want to go over some questions you're going to ask the witness that already said they're going to plead the fifth? Why? Why would you do that? I'm sorry. I'm thinking as I'm reading. All right. Well, Miss Hilton has already shared it with Mr. Copeland, and we certainly will share it. Generally speaking, Ms. Bumpers, can I read this email that Melnick sent me? I don't know if this will help you understand what he's saying. It says, "Hey, Kayla, I wasn't able to see Kenneth today. He went on Saturday and tried to talk to him before his flight, but I have talked to his family. So at first, Kenneth was going to testify, but has now decided to take the fifth. He may change his mind on Monday. If he does, then he's agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA's office, so I can't really help him with his testimony. Not his witness, his testimony. How to testify and what you witness is two different things, okay? And then he gave me the discharge and told me that if he decides to testify, then he'll sign this. Ms. Love, and that's just it. It's like you never know what somebody is going to ask. And if he's concerned about putting him in legal jeopardy, then it would seem like he would remain and allow Mr. Copeland access to counsel when Mr. Copeland is concerned that he's about to walk into an area that puts him in legal jeopardy. Ms. Bumpers, you can't switch how he gets called. See, Ms. Love, see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. When you say switch in how he gets called, what does that have to do with anything? I don't know. Maybe he's saying he can't do it because he can't get his refundable ticket. Ms. Love, that is not what he said in the email to you. And that is not what he relayed to the court. And his concerns have nothing to do with he was very much, that's what Glanville cut him off. Ms. Bumpers, I tried to go back and watch as much as I could. The court telling me that he was going on vacation. And I said, well, you inserted yourself in this. I said, really, you need to come on Monday. Ms. Love. So he can't force Mr. Copeland to discharge him just because Mr. Copeland decides to testify. But that's what they agreed to. Lord have mercy. Glanville, I think you are in until it's done. I mean, Ms. Bumper said, who, me? Ms. Bumper was like, who you talking to? Man, I'm about to go back to Houston, dog. What you talking about, player? What you talking about, Pimpin? The court. Hey, yeah, I mean, if he testifies, you got to kind of Ms. Love. And frankly, Your Honor, I know that if a person faces criminal contempt, they are entitled to representation if they want it. This being a civil contempt matter. And of course, not necessarily. Anybody who's facing contempt can get counsel. I mean, not anybody, but Ms. Bumpers, I can't stay. How long is this going to take? Ms. Love, it may take some days. Ms. Bumpers, Love, and see, that's just it. I think Ms. Bumpers is put in a precarious position. She's not the one that stood up and injected herself into the. I mean, they are bullying. They are some bullies, man. Skip what was talked about between the attorney and the client, the previous attorney and the current attorney. Skip what the client said to these people. Y'all gonna have to be here regardless. This is crazy. Absolutely insane, man. They reached out to her and she did him a favor. But ultimately, it seems as if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings. And that is a problem because that has nothing to do with the best interest of Kenneth Copeland. Like you care about Kenneth Copeland. Y'all don't care nothing about no dang on Kenneth Copeland. And that has nothing to do with Kenneth Copeland's exposure if he testifies. Just to answer the question about what he is exposed to, the statute is very, very clear. It literally says that no testimony or any evidence required under the court's order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for the crime or offense concerning which he testified or produces evidence under the court order. It sounds like the man had total immunity, because total immunity sounds like this. When a person says that, this part right here, that's important, concerning which he testified. So in any proceeding or representation or prosecution for a crime or offense concerning which he testified. So they can't charge you for anything within the testimony of the case or anything that you've done previously, especially with the statute of limitations. But anything that's dealing with the case that you did, if you did something wrong in the case that you testified and you testify truthfully, they cannot do anything with you. You see, this is what they're basically saying. That is saying, even if he got on the stand and said the court, he started talking about an unrelated crime, which is what the biggest thing I think he's probably thinking about is that, yeah, there's a lot of stuff they could ask me, but about Ms. Love, right? So that is known. That is not known to a lot of people, and that, you know, he could also invoke his Fifth Amendment with the advice of counsel if it was some other particular crime. But even that, we wouldn't even that. He still have to testify. Ms. Love, literally, right? The law says, it's supposed to say the law says, said the Soleils, but the law says, yeah, I mean, anything he testifies to. Ms. Love, we do this, Ms. Bumpers. Okay. And then about the delay or stall, isn't it true or is it not true that he had a leave filed since December? Ms. Love, we have nothing to do with any of that. He injected himself into this. Yeah, see, the problem is, Ms. Love, he stepped in the court. That when you get involved, I don't know, you have a leave. Ms. Love, right, you, the court, and unless you filed that leave into this case, you don't have a leave for my case. Ms. Love, right. Bumpers, okay. Love, and he did not, Glanville, so he didn't have one. So they saying Melnick didn't have a leave. Ms. Love, Mr. Copeland's been a witness and a name on this witness list since he said, well, I represent him. I'm like, okay, well, you don't have a leave that's filed in our case. Ms. Bumper said, okay. Ms. Love, so he did this to himself. He did it to you, but we have to, that is just where it is. And I don't know that that's just where we are, Ms. Bumpers. So, Judge, you are going to make me stay if he chooses to testify. We just on page 18, y'all. We're almost there. The court. I mean, I am, because you're his lawyer. You're his lawyer. You're a stand-in lawyer at this point. Ms. Bumpers, Your Honor, I don't have a problem with that. I'm not ready. Ms. Love, if court, there's nothing for you to be ready about. What? Are you kidding? What? There's nothing for you to be ready. What? You're joking? There's nothing for you to be ready about. I mean, here's the thing. I think the only thing you've got to kind of ask him about is, look, here is the questions the state is going to ask you. Look at the coercion like a mug. All right. Is there anything else that could hurt you that they might ask you about? And as long as you have knowledge of that, then I think that you are fine, because the state's only going to get into this. Now, the reason you want to know what's going to hurt you is the defendants know more about Kenneth Copeland than anybody else. So they are probably going to kind of, well, what about Bumpers? What about if I say I can't do it? Then Melnick needs to come back, right? Am I going to be in trouble? Because I was only for Monday. That's what I was told. I was given specific love. If Copeland said, I don't know what Mr. Copeland wants, it's his choice. Bumpus, can he say he doesn't want Melnick? Miss Love, he can say whatever he wants. It's his choice. I mean, that's the thing. If he can say whatever he wants, guys, if he can say whatever he wants, you're not accepting whatever he's saying. You're still trying to force him to testify. You're still trying to force him to have representation. You're trying to force him to do you're trying to force him to go against everything that he told him and his attorney about. This Ms. Bumpus. But the judge is saying, Love, I don't think he can be forced to have representation if he doesn't want, need, or say he wants it, because we have done everything to clear him of judicial exposure. He's not, there's nothing he can say. He could lie. That puts him in, the court peril. Wow, man. This is a judge. Miss Love, peril. But he can't talk about a crime that we could then prosecute him for. Wow, man. This is crazy, man. This is our court system, guys. That is involved in this or something or some other place. He can't talk about a crime that we could then prosecute him for that is involved in this or some other place. I mean, but now I feel like the immunity is restricted, got limitations on it, it seems. Ms. Love, right. Ms. Bumpers, I understand that, but we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded. That's what Ms. Love is saying. And Bumpers is saying, I would have to agree with you that I don't think that that's the concern. Isn't that what you said? Ms. Love, well, the court said that. Ms. Bumpers, no, I'm saying with Mr. Copeland not testifying, you said you don't think that his concern is criminal exposure, or you do think that is what he's worried about. And the court says, do you think that he's fearful of testifying for other reasons, like for personal safety? Right. Right. And Ms. Love is saying that is what Mr. Melnick said to me in an email I can pull up, he said. And then Bumper said, but you don't believe that. Ms. Love, you are going to get him killed. She put up the email. You are going to get him killed. That's what he said. We ain't gonna kill him. Oh my God. Ms. Love, dog. She is such a manipulator, bro. This is crazy, yo. This is crazy. I mean, this is mad crazy manipulation right here. Like, you don't understand what he's saying? Ms. Bumper, see, I don't know anything about that email. Ms. Love, we ain't going to kill him. I can show you the email, but we're not going to kill Mr. Copeland. So who is he talking about? So what are you trying to do? Now she's trying to get information. She's trying to see if it's Young Thug, or she's trying to see if he's been threatened before so they can use that as a. See, that's what. Oh my, you're in the ex parte. You're in a secret meeting right now, okay? Right? You're in a secret meeting right now, and now you're talking about we ain't gonna kill him. Like who's going to kill him? Who's going to do this thing to him? Right? Stop it, man. It ain't gonna be us. So who said that? Who threatened him? The court. This is the court. This is a collateral second and third order effect. Let's pray it doesn't happen. But what the? Mm-mm. 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 Hey, did the judge just say that Woody was a collateral? I know I just read that. I know we all just read this. But we ain't going to kill him. I can show you the email, but we're not going to kill Mr. Copeland. So is he talking about? So who's he talking about? So what are you trying to do? That is a collateral second and third order effect. Let's pray it doesn't happen. Dang, dog. Let's keep reading, man. Dang. That's a judge, man. That's the chief judge saying that this dude is collateral second and third order effect, bro. Let's just pray he don't get killed for testifying. Miss Love. I mean, obviously the court first he has to give the testimony though. I mean, that's what he has to do. He's got to give the testimony, whatever it is, good, bad, or indifferent. Good, bad, or indifferent, I should say. So Miss Love is saying, so we would like, with the court's permission, they haven't brought him over, and he was supposed to be the first one up. So I guess they went to get him. They might be over here with him now. Page 21. The court. Is he here now? Miss Love. I don't know. Judge Glanville exited chambers at 9:33 a.m. We would like, Miss Love, we would like to just go into another courtroom and talk to him. Give you a chance to talk to him. And then give you an opportunity to explain to him. The court reporter, we're off the record. Brief recess. Wait a minute. Glanville exited the chambers at 9:33 a.m., right? It says here, we're off the record. Brief recess. Judge Glanville and Mr. Chamberlain entered chambers at 9:34. What? You exited chambers and you walk right back in? Oh, I think y'all might be I think y'all might be right about this. Right. All y'all that hit the like button, y'all might be right. It sound a little doctored. Little Dr. Pepper. Miss Love, Miss Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. Court, where's Mr. Copeland? Mr. Chamberlain. They took him upstairs to the tank in 9. Okay, can we bring him out to can we? Ms. Chamberlain, yeah, your chambers is being used. I mean, your courtroom is being used. The court, let's bring him in here. All right, so let me see if I can get that done. Let's bring him in here. Okay, thank you. We'll just bring him in here. The proceedings stood in recess from 9:34 to 10:03 a.m. It was in recess. Mr. Copeland entered chambers at 10:03 a.m. All right, here we go. Also present was Glanville, ADA Hilton, Bumpus, court reporter, investigators, Long, investigator Hamilton, Deputy Houston, McPherson, Sergeant Brown, Sergeant Hall with the Fulton County Sheriff's Department. Okay. Copeland, Glanville, Mr. Copeland. Can you let him know I got a hearing problem? Woody, man. Can you let him know I got a hearing problem, man? Ms. Bumpus, okay. He said he is hard of hearing. The court, all right, that makes 2 of us. I've got a hearing aid that's coming on the 27th of June. So I'll try and talk loud, okay? Is it okay if Ms. Copeland? Yeah, I can read lips. All right. Okay, good. Mr. Copeland, good morning. Good morning. All right. I just wanted to bring you over and let you talk with Ms. Bumpus and see if there's anything that you need to ask or your counsel or Ms. Hilton or the state or the court before we bring you out this morning, because we would like to hear your testimony, and that is kind of where we are at this point in time. He let us say that at this point in time. So is there anything you want to ask, Mr. Copeland? Well, I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. I don't know. I don't comprehend none of this stuff that's going on in the court. Okay, well, the only thing you can give is truthful testimony. I mean, whatever you know is whatever you know. I mean, that's it. Ms. Hilton. And what we'll say, and Mr. Copeland and I, we have talked about this. I'm not sure what your concerns are, what your concerns that you expressed to Mr. Melnick last week. But if you are, and if any of your concerns deal with being locked up or anything, you can't. Like there's nothing that can happen. The feds, well, that's not, it's true. It is true. Ms. Bumpers, no, I said that's not his concern. Ms. Hilton, if his concern is safety, we need to know that. Like that's not expressed. So we don't know what the concern is. That's why we can try to resolve the concern. This is what I'm saying. Mr. Coleman and I have had conversations before. I understand some of his concerns, his potential criminal liability, hence why we gave you immunity. The federal statute of limitations, done. The state statute of limitations, done. So there is nothing. Like I researched it this weekend, over the weekend, again, but those statute of limitations for what you and I talked about, which is in 2015 or before, done. You cannot be prosecuted for anything you testified federally or statewide. Immune, period. So total, it sounds like, okay, so Ms. Hilton is saying that it sounds like total immunity, transactional immunity, which is total immunity. Okay. So if that is the concern, there is none because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been in 2020. Anything statewide is 4 years. It would have been 2019. Finished. Next concern, what may happen in the street? You know what we have talked about, what we can do as far as living and all of that. We have had those conversations. So I'm not trying to express to you, we do not want you to lock up. I'm trying to express to you, excuse me, we do not want you locked up. I don't know how many times I've got to tell you that. What I've got to say to you, we do not want you sitting in DeKalb or any other county jail, whatever they got you because of this. I know you wanted to talk to me on Friday before you walked into court where you weren't able to talk. If you still want to talk with or without Ms. Bumpers, I'm here. But we do not want you in custody. What do you mean with or without Ms. Bumpers? Are you crazy? You will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution, any of it. Literally. Judge, you might want to close your ears. If you confess to a murder, if you confess to a murder on the stand, if we don't have any other independent evidence outside of what you said on the stand, you are immune from prosecution from what you say in court. Remember that time when Miss Hilton asked Woody if he killed Big Nut? Ooh, he said, nope. Nope. Wow, man. Look at this. Look at this. You might want to close your ears, Your Honor. Okay. Oh my goodness. Ooh, they dirty. Ooh, they dirty. You're immune from prosecution from what you say in court. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Ms. Bumpus, and I told you, that is what this order says, the court. And that is direct or cross-examination. Ms. Hilton, that is direct or cross-examination, court. So if you are worried about what the defendants may ask you, because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those things. Mr. Coleman, man, I got family members watching this trial, and I don't want my nephew, I don't them to hear the things that I may be involved in and think it's okay. Ms. Hamilton, but I think that's a separate conversation you can have with them as an honest individual. Like, look, nephews, I done lived the life that I don't want you to live. Don't go through what I've been through. But that's something you can have outside of being in jail, because That's a better conversation you can have with your nephews in person. But they shouldn't have to come to DeKalb County Jail because you are being held in contempt. You can have that conversation with your nephews tomorrow in person. You can have that conversation with them. You can have the conversation with anybody. You know what's coming up this weekend. Why are we in jail? What are we doing? Copeland. But y'all did this intentionally. Hilton, no, we did not. You and I had this conversation, Mr. Copeland, on Friday morning. Yo, you knew my child's birthday was next week. Hilton. But what did I tell you? When we met with each other, I said to you, you asked me, what is the one thing that's going to keep me in jail? Didn't you ask me that? And what was my response? Excuse me, I got to take a little drink. If you plead the fifth, and that is exactly what you did on the stand, but they knew that before. Mr. Copeland. But what did I tell you before I got to that point? I told you the whole time Tuesday, Wednesday, Thursday, but I told you we were giving you immunity. Oh, whoa. But what did I tell you before I got to that point? I told you the whole time, Tuesday, Wednesday, Thursday, but I told you we were giving you immunity. I told you that I was pleading the fifth. No, you did not. I told you every day I was pleading the fifth. No, you did not. And we told you, I told you my concern. And we said we could give you immunity. You said your concern is what they know about you. And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns are, we can give you immunity. So I didn't tell you I lied on them to get myself out of the situation. You said you were a liar. That's what you said. You said you were a liar. Was this on the record? Was this recorded? Miss Hilton? No. Bumpers. And did he ever say that Melnick was his attorney? No. This week, when we first met, this week, look at that, this week. So you met him. So the week of, come on now. He's been his lawyer before that. This week, when we first met, you were in the car on Friday. We asked you, is Mr. Melnick your attorney? You said he's not my attorney. I haven't even talked to him. Mr. Copeland, no, I never said he's not my attorney. I said I haven't talked to him. Ms. Hilton, you said he's not your attorney. See, not you said he's not your attorney. You haven't talked to him. Then we continued to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone. The man said, no, I never said he's not my attorney. I said I haven't talked to him. You didn't make me feel like I needed him. Ms. Hilton, but if you needed him, we would have said, if you would have needed Mr. Melnick, we would have said to you, okay, just call him. Nah, man, this is crazy. This is all messed up. They twisting it all up. They are twisting this thing all up. So, I mean, that is our position. We don't want you in jail. We want you to be able to purge yourself by testifying. Whatever your truth is what your truth is. But you've got to testify. You got to answer the questions. We believe that whatever your truth is, whatever your truth is, we know what you said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions, I know what you said before, and I know what you said later. I mean, I know what you said before, and I know what you said, and I know what you are going to say on the stand, because you and I never went into full details about any of it. Oh, I don't know what you're going to say on the stand. I'm sorry. But what I don't want is you to be sitting here in custody. You did it. I did not do it. You did it by pleading the fifth. You told me before you went to the judge with whatever the thing called you went to him with, the immunity, you told me that I can't, when I'm ask the question, I can't say I don't recall or I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do. And then you was like something. And then y'all called, asked for this immunity. And I was like, it was something. And then Thursday or Friday came, and then y'all go tell me, we went to the judge with this, so you got to testify. If you don't testify, the judge gonna lock you up. Right. But that was based upon but I told you all that. No, you didn't. Copeland, you said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened. Miss Hilton, and I said, I don't know what happened. Only you know and them know. I said, but you never said I'm pleading the fifth. You said, what if I do this? 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 I told you, I said I'm going to plead the fifth. You said, why would you plead the fifth to something that you didn't do? Bumpus. So if you didn't have immunity prior to, is that what you are saying? That you feel like he didn't have immunity prior to? Mr. Copeland, immunity came Friday, right when I went to jail. Exactly. He saw the immunity papers the same time we all saw the immunity papers. Everybody in America saw those immunity papers, okay? Everybody in America saw the same thing. And they gave him immunity right there on the stand. They never gave it to him prior to. Because prior to that, he said, I'm going to plead the fifth. I'm going to plead the fifth. They tried to even coerce him with immunity. Jeez, oh Pete, dog. Immunity came Friday, right when I went to jail. The immunity only came after Mr. Melnick. Oh my God. Hold on. Ms. Bumper says, Ms. Hilton, the immunity came after Mr. Melnick sent us an email saying my client is pleading the fifth. That was on Thursday evening at 6 o'clock. Ms. Bumpers, okay, Ms. Hilton. So after that, that was an emphatic. He is pleading the fifth. Ms. Hilton, we came and we got this sign. And then Friday morning came. Okay. So between Friday evening, Mr. Melnick reached out to us and said he represents him. He's pleading the fifth. Okay, Ms. Bumpers. And when was the last time you talked to him before Melnick got involved? We talked to him earlier that day on Thursday. Okay, and then and then it speaks inaudibly to Mr. Copeland. Mr. Copeland, he called me, Ms. Bumpers. Okay, I was just trying to get a timeline. Ms. Hilton, so sure, right. So when we have been talking since last Friday, so I met with Mr. Copeland last Friday, I think out in the neighborhood. Then he came on Tuesday for court. We talked briefly on Tuesday. And then on Wednesday, he came. Okay, Thursday. Little Woody. Thursday. All right. Ms. Hilton, no, I think he only came 2 days. So it had to be Wednesday and Thursday he came. It wasn't Tuesday. It was Wednesday and Thursday he came. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went to the next morning. So he said, look, Thursday, once they left, Mr. Melnick reached out and said, my client pleading the fifth. The next morning, what's after Thursday? Friday. That's when they got the immunity motion. So again, when Woody got approached with immunities, we did too. America, hey America, we all got approached with immunity that day. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we can't use. And then Mr. Melnick came, and then we had court. Whatever. So you are pretty much saying you didn't ask for this. Mr. Copeland saying, I didn't. Mr. Hilton said, but we gave it. He didn't have to ask for it. I know. I mean, he's just saying, right. He doesn't have to ask for it, but to alleviate whatever his concerns were, we gave him immunity. He didn't have to ask for it, Ms. Bumpus. So if he wouldn't have had this, I'm just saying this so he can understand. I'm walking him through. Would he still have had to testify, or would he have been able to plead the fifth? That's what he's saying. Ms. Hilton, if he did not have immunity, yes, he could plead the fifth. Mr. Copeland, that's what he's trying to say. He's trying to say he didn't ask for this. He doesn't want immunity. He doesn't want immunity. He wants to plead the fifth. You're trying to force immunity on somebody who don't want to testify. Coercion, Ms. Hilton. But he doesn't have to ask for it. Oh my God, these people are crazy. Now that we have given it, even if you don't have to ask for it, that's fine. Let's take let's take her statement right there. You don't have to ask for immunity. That's true. You don't have to ask for it. You can be given immunity. You can be offered immunity. That's fine. But you have to agree to the immunity clause, the immunity plea. You cannot be forced with immunity. You have to do something to make me want to sign the immunity agreement if I don't want to sign it, or if I don't want to be a part of it. You can't say, I filed a motion of immunity on you, now you got immunity. No, I have to accept it. You offered it to me. You didn't give me anything because I didn't accept it. I don't want immunity. Crazy. Where we at? Right here. All right. So now that we have given it to him, because that's on us. So now that we have given it to him, it's in order. Immunity is in order? Wow. No, well, testifying with immunity is in order. Under immunity is in order. He can still choose if if this is the role he wants to take, then he'll just stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried. That's even the guys that went through the plea deal that they all rejected last week. Remember that judge? I forgot the judge's name, man, but he was every defendant just denied immunity. They don't. I mean, not immunity, but the plea deal, and the plea deals was crazy. I heard that it was kind of crazy, and they was like they want a date for trial, So she's talking about all those defendants. She's talking about every last defendant has been tried. So he got to stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried, man. Not just these 6, the other ones too. Dude, Copeland, I done did longer time. That boy is scared. That boy crazy. Ms. Hilton, all right, Mr. Copeland, I'm telling you that you are literally immune from prosecution from anything else you may say. That's it. So the choice is always up to you, but we wanted to put on the record the state does not want you in custody. What the state would like you to do is purge yourself from. What purge yourself mean? What you mean, Hilton? Meaning that you are no longer in custody. The way that you purge yourself is to testify. That is kind of how it happens. And that is what the state wants you to do. We don't want you in custody. I can't say that any other different way, but we don't want you in custody. The other thing that's holding you is you refusing to testify. I mean, they're going through all this just to get Thug, man. I mean, they're going through so much stuff just to get young Thug. This is crazy. This man, the boy done say he don't want to testify. You gonna throw immunity on him and make him accept it like he agreed to it. Oh my God, man. This is why you gotta lawyer up, man. This is why you have to lawyer up like for real. So, do you have any questions? Any other questions? Basically, if you invoke the fifth, I don't trust. I don't trust. I don't know what's going on. I don't trust nobody. I trust her word, but I don't know what's going on, Your Honor. Hilton, this is your insurance. I don't know if you want to break that down to him, Ms. Bumpus. Well, he doesn't want that. that's what Ms. Bumpus is saying. He doesn't want to. The court, but he's been given it. That doesn't mean he has to accept it. See, that's the challenge, Mr. Copeland, is that if they didn't give you immunity, you can invoke your Fifth Amendment privilege. But what the state decided is the state decided. What the state decided is they said your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they have made from the state's perspective, they have made a decision to give you immunity, so you no longer can invoke your Fifth Amendment privilege. You have to testify. So that's the difference in this particular scenario, is that they have taken away. Well, you can still invoke your Fifth Amendment privilege. You still could do that, but the consequence of invoking it is you will just remain in custody. So if you testify, you can get out of custody. You can stay out of custody until you're done. And then if I don't testify, I have to stay in until when? Until the trial is over, until all the defendants, Glanville, until all of the defendants have been, and I've got these 6 that we have right now, and then there's another 6. No, there's another 12. Oh, there's another 12 or thereabouts that are still outstanding in various forms or another. God, 18 defendants, man. 18 defendants. Come on, man. That's crazy. Mr. Copeland, can I speak with her for a second? Court, yeah, sure. Glanville, 88 Hilton, court reporter, Weaver, investigators, Long, Hamilton, left chambers at 10:17 a.m. and returned at 10:33 a.m. Oh, somebody lying. Somebody lying. I thought it was an hour. Let's see. Let's see what happens. My question is, I can ask you a question. My question is, can I ask you? I can ask you a question. The court, yes. So I guess so they left in chambers for 16 minutes. Came back. Woody had some questions. Yes. So my question is, so what I was just asking her was, if you asked me a question and you feel as in I was lying about it, you will lock me back up. Hilton, no. If you are saying, you say, I didn't talk to Demikian. Well, no, I can't talk about that because the judge is in here. You are asking, for example, if you said before that the sky was blue, and I asked you, understand, what color is the sky? And you say, I said it's red. I'm going to say, no, back before you said it was blue. Is that what you're trying to ask me? So explain the independent evidence. If he says he did something, and you know he's not telling the truth, what happens? There you go. Redirect, get them back in line. There you go, Bumpers. Hilton, if he said he did something and he did not do that thing, Bumpers, if you believe he did it, so if you believe that he's lying about it, then no, he admits to doing something on the stand. And he did not do that thing. I'm going to say, is this the first time you are saying that, Bumpers? And you have independent evidence to prove it wasn't him. Then what? So you got evidence to prove that it was him or not. Then what? Then nothing. What do you mean, like, Ms. Bumpers? So then will he be so then he will be fine? Hilton, yes, but so you are okay with him if he got on the stand and said things that weren't true? Hilton, no, I want him to tell the truth. What I have always said to you, what have I always said to you? I want you to tell the truth. I don't know what's going on. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that is inconsistent with what you said before, then I'm going to ask about the inconsistencies. But I expect you to tell me the truth. What you go on the stand and do, I don't know. I don't know what you are going to do. I want you to tell the truth, but I will deal with you not you saying something different in the manner that I normally do. Mr. Copeland, if I'm saying something different, right? So when the police question me, they don't question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them. Miss Hilton, okay, so you can say I don't recall. Look at this. Look at this. That is how that works. I don't recall. Miss Bumpus. And he can say that every single time, every question he can say that. Right? Miss Hilton, I would hope that that is not the truth, because I think there are some things you do recall. There's some things you don't, but the things you don't recall, you don't recall, and the things. And I will go through the process. I will go through my process of what I do. You could talk about him. You could talk to him about the what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You could talk to him about the what impeachment is. If he says I don't recall, Copeland, what will get me locked up? Hilton, what did I tell you? I don't know. What you did on Friday? I plead the fifth. If the court instructs you, Mr. Copeland. So the only thing that gets me locked up is pleading the fifth. Yes, Ms. Bumpus. Ms. Hilton, the court instructs you. You need to answer the question. You say again, I plead the fifth. And again, that's what's going to get you locked up. But if you answer the question, that will not get you locked up. Copeland. So if you don't want me to in jail, why you just don't let me go after the trial over with? Why don't you let me go after the trial over with? Ms. Hilton, you are in jail because you are not answering the questions. The court, because you have been given immunity. Because you have been given immunity, Hilton says, you are only in jail because you got up here. She's reiterating and emphasizing what the court says. Mr. Copeland, well, what was so he said, well, what about this? I answer the questions. You take away immunity. I answer the questions and I plead the fifth. Ms. Hill, no. Copeland, to questions that I feel incriminate me, but then I won't plead the fifth to things that don't incriminate me. The state can still give you immunity. They can give you immunity to whoever they want. Okay. And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure that the jury needs to hear what you have to say, good, bad, or indifferent. And what Miss Hilton is telling you is just tell the truth as you know it and let her worry about, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you in trouble is you just invoking your Fourth Amendment privilege because you have been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. That particular false statement. Mr. Copeland, that's what they're going to do. Ms. Bumpus, this is what I was saying. You will be right back here. And then Ms. Hilton speaks. But if you say something that you know you did not do, like you admit to something you know you did not do, whether you like murder, don't have no statute of limitations, right? Like murder don't have no statute of limitations, right? But if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it, Copeland. But y'all don't. Like Ms. Bumpus, you could charge him with false statements. He will be back in jail. This is what I'm trying to say, Ms. Hilton. But if I know that you are lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you are trying to say you did now. And that can be a part of this. I know you didn't do it, Copeland. But if it's up to the judge to do that, no, it's up to the state to bring charges. The court, I don't have anything to do with that. Well, you in this meeting, you got something to do with something. Ms. Hilton, he has nothing to do with bringing charges. That's up to the state of Georgia. Can I talk to my family? I will make my decision right after I hang up the phone. Bumpus, he's saying he hasn't been able to talk to anybody. His sister just called us. She, Copeland said, y'all done did me wrong, man. Y'all just hold me in jail. Don't let me get no PIN number, no nothing. Hilton, we have no knowledge. We did not know that. He hasn't been able to do anything, speak to anyone. Bumper says, Copeland, the jail system down, but y'all still putting people in. Miss Hilton, that part I don't know. I know we have been in communication with your sister. Your sister actually texted Miss Lancequat to make sure you were okay. We told her we physically have laid eyes on you. I'll leave that up to the sheriffs. I don't know. Brief pause. So what you think was what you think was she saying? So what you think was she saying? Hilton, I can tell you right now, Copeland, I'm talking about that locking me back up. We would have to bring charges. There would be no incentive. Y'all will. Hilton, we've already had this discussion. Copeland, look what you did to me. You waited until Friday and did this. Whoa. You waited until Friday to did this. Dang. I done told you every day before Friday came that I was pleading the fifth. No, you did not. As a matter of fact, the court, Mr. Copeland, let's see if we can get beyond this, okay? Beyond what your concern is. You could have invoked the Fifth Amendment privilege. The state would have, this is getting redundant. The state would have turned around and said, stop, had me go ahead and file that motion and giving you immunity. It was going to, they make that decision. They decided to make it on Friday. It's bullshit. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness. They want your testimony more than they do you invoking your Fifth Amendment privilege. So they gave you immunity. They gave you immunity so you can't do nothing but talk and snitch. They gave you immunity so you have to testify truthfully as to what your knowledge of this particular incident is. So they could have done that anyway. Even if they put you on the stand, they could have said stop and go ahead and giving you immunity. They could have done that. So, Woody, I'm sorry, Copeland. So can I get it in some time of writing that if I was to testify that if she feels as in I lied about anything that they won't lock me back up? The court, let me have that, Ms. Bumpus. Ms. Bumpus hands the document over to the court. Brief pause. The court, Mr. Copeland, on page 2 of the order pursuant to OCGA 24-5-507. However, no testimony given by Kenneth Copeland as required under this order or any information directly or indirectly derived from the testimony of Mr. Kenneth Copeland given by Kenneth Copeland as required under this order shall be used against said Kenneth Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under this order. Okay, so you testify about some aggravated assault or murder, they can't prosecute you on it because that is what it says on the order. Okay, the only thing that will get you in trouble is the next little paragraph. Kenneth Copeland shall be subject to prosecution or to the penalty of forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with order. Yeah, they gave him immunity. They gave him total immunity. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court in this state, the United States, or any other state. So basically, if you commit perjury, false swearing, or contempt committed in testifying, that means if you just invoke your Fifth Amendment privilege or failing to testify, you say, I'm not going to testify, all right? So the only two real things you can get in trouble for is perjury, false swearing, or not testifying, pleading the fifth, right? That's it. Should have said that too. Now, as Ms. Hilton and Ms. Bumpus said earlier, you may have told or been asked about situations over and over again. They may have changed. What the state is asking you to do is tell the version of that really is the truth. If they want to impeach you, they can do that. Or if if the other side wants to impeach you, they can do that. You won't get in trouble for that. You said I will, Mr. Copeland says. With the court, you will not. You will not. Impeachment is not perjury or false swearing. Okay, Mr. Copeland. But she said I can purge myself, though. Miss Hilton, no. We were saying two different things. Sorry, perjury is if you get on the stand and you say just a bold-faced lie, just something that is just wrong. Say you say I did something, and all other times you have said I have not done it. And really, while it's perjury, it's really just an inconsistent statement. Like if you get on the stand and say I did X, but in 2015 you said I never did X. That is what I'm going to impeach. I'm going to impeach you on everything you said in 2015, meaning I'm going to say, okay, today you said I did X, but in 2015, Lieutenant Dean enters the chambers. Lieutenant Dean, we have a security situation. We have a security issue. We need to stop for a minute. If we can, stop for a second, please. Wow. Okay, that's abrupt. Judge Glanville and Lieutenant Dean exited the chambers at 10:45. Glanville returned at 10:47. Hilton, I don't know what was told to you on Friday. I have no reason to want you in prison. You spent enough time in prison for YSL, period. So why would I want that for you? That doesn't make no sense. I said it to you before, and I will say it to you again in front of all these people. It makes no sense. Mr. Copeland, you just said I'm going to have to stay in jail until the last. And you know what's so funny? Let me go back real quick. This right here is crazy. You exit the chambers in 10:45, come right back, and you said there was a security issue. We need to stop for a minute. If we can stop for a minute, please. Wow. Okay, that's crazy. What was that? All right, Mr. Copeland, you have just you just said I'm going to have to stay in jail until the last. If you don't testify, get this part through your head. If you don't testify, that is the only thing that is holding you. That is literally the only thing that is holding you right now is the fact that you're not going to testify. Keep saying I'm not going to testify. Well, if you haven't said it today, I'm not testifying. I plead the fifth. Well, you haven't said it today. Is what I'm going to say. If you get up there and I want you to tell the truth, like I said before. But if you get up there, you say if you don't recall certain things, you can say you don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail in 2015. I just don't. No one in here does. But what I do expect for you to do is answer questions so we can get through this, so you can go home, be with your baby for her birthday, see these dogs delivered, their babies, go talk to your nephew, do all these other things. How you know about my dogs? Woody, man. Because you told me. Oh, okay. What's wrong, Bumpus? I'm stressing at another level, like, I mean, can he? I'm saying, Mr. Copeland, I'm weak. Man, I'm not playing. I'm dead serious, man. Like, Hilton, This is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And you have you have to make Ms. Bumpus. If he decides in 2 weeks he wants to testify, then what? If he wants to stay in jail for 2 weeks, then I don't know why you would want to stay in jail for 2 weeks. I have no idea. Ms. Bumpus, he just feels like he's under a lot of pressure right this second. And he is. That is a good statement right there. He just feels like he's under pressure. What is that pressure called? Coercion. Coercion. Mr. Copeland, even at the jail, they are just, you can't give me house arrest? No, you can go home by taking the stand and testifying. That's what and come back tomorrow. There's no, we keep on saying yet, but there is no crime. We keep on saying yet. I don't know who is telling you about a crime. There is no crime. You have done nothing wrong except for not Copeland. So why am I in jail then? Because you aren't testifying. But that ain't nothing wrong. It's not a crime. Ms. Hilton, it's not a crime, but you're in civil contempt. The court, two things. Because you invoked your privilege after you've been given immunity, that is why you're in custody. Because you get out by testifying. So you testify, you get out. That's why I was going to bring you, why I brought you here early today, to just inquire about that. Yeah, inquire. Coerce. You can remain and hold your position of invoking the fifth or not testifying, but you go back to prison. You go back to jail because that's Mr. Copeland. You can't sentence me. Ms. Bumpus, there's no sentence. The court, there is no sentence. The contempt is compliance. They want your testimony. That is all they want, whatever that may be. Copeland, I don't know what it is, Your Honor. Hilton. So listen, you are in jail for failing to testify. The court, failing to testify. Hilton, not for nothing else. There was no crime. You ain't done nothing wrong. I don't know if people are telling you that we are going to charge you with anything or charge you with nothing. We are not charging you. The state charges you. There is nothing we're charging you with. You are only in custody because you have decided not to testify. That is it. Once you decide to testify, I mean, you gotta understand that this is really wild because you're telling somebody that you didn't do nothing wrong except for not testify, but you had then handcuffs. So mentally, how can you distinguish the two? You know what I'm saying? How can you actually do that? How can that person at that time process that I haven't done nothing wrong and that you promised me I won't go back to jail again if I testify and just say I don't recall a bunch of times? Come on, man. How can that person trust that? The court, remember that word you were talking about, purge? Mr. Copeland, okay, you can purge right now. Purge, get yourself out of jail just by testifying. I can purge and get out of jail? Yes, just by testifying. Not perjury. Purge. Court, purge, meaning you can get out of jail. You can get out of jail, out of custody, just by testifying. Putting in work, people. And what about the other one? The other word, perjury, Copeland. That's different. Court, Glanville said, yeah, that's different. Hilton. Yeah, that's a different word, okay? Copeland. That can get me back in jail. Hilton, yes. Perjury is, Miss Hilton, it's not, what you are saying is not perjury. What you are saying is what we call a prior inconsistent statement. Here we go. Your example that you gave me, what if I said I did something and I did, and I know you didn't do it, and you said before you didn't do it. That's not perjury. That is a prior inconsistent statement. Brief pause. Ms. Bumpus, you've got to make a decision. So if he starts testifying today, he's going to go home today. Ms. Hilton, he should, so long as he remains. But if you get up there and be like, if you get me if you be up there and you be like, if you get to testifying and then we get into it and you start saying I plead the fifth, we're going to be back here again, Ms. Bumpus. But if he says he don't recall to everything, he'll be okay. Ms. Hilton, I'm not advising that, but so long as he answered the questions, that's fine. So long as I did, Mr. Copeland, I did these crimes. I'm telling you that. Oh. Oh, he said, I did these crimes. I'm telling you that. Okay, I don't know what you are talking about, Ms. Bumpus. I think, are you saying you want to get up there on the stand and say something? Mr. Copeland, no response. Okay, Ms. Bumpus, did we find out if he could talk to his family? No. Brief pause. Ms. Hilton, I mean, if that's okay, she said, if it's okay, we got the sister's number. Copeland, as my attorney, you got to, Hilton, if y'all want to talk, let me go somewhere I can't hear you. The judge is over there, so I just speak low so he doesn't hear you. The court, hold on. Glanville handed a document to Attorney Bumpus and exited chambers with ADA Hilton, Long, Hamilton, and the court reporter Christina Weaver from 10:53 to 11:28. And they're back. And the court said, okay, all right, Mr. Copeland, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions? Ms. Copeland said, no, Your Honor. The court, is it your desire to give testimony today? Yes, sir. Wow. Okay, all right then. Do you all have some clothes for him? I don't know. Let me go take a look. What size are you? Copeland says, I can't hear you. She said, what size are you? He said, little. Investigator Hamilton. We had a large jacket for him Friday. Large. And Hilton said, you had a jacket for him? And Hamilton said, yep. And Hilton says, oh, but he can't wear large. The court, what is your waist size? 34. Copeland, 32. Court, chest, are you a 34, 36, 34, 36 in chest? No, probably 36. Copeland, not my chest. What you mean? What you mean? The court, size. Hamilton. I'm sorry, Hilton. What size are you? Small or medium? Copeland, small or medium. They are going to try, the court, they're going to try to get some clothes so you don't have to testify wearing the jail uniform, okay? Copeland, y'all don't want to show the people how y'all did me? Court, look, Hilton, if we can't find clothes, then you may have to until tomorrow. Copeland, I prefer to go in like this. So it was his idea to go in on that Monday to testify in the jail outfit. Miss Hilton, I understand what your preference is, Mr. Copeland. No, don't hide it. Can you make him? Can you make him put on clothes? Miss Bumpus says. Hilton, nope. Copeland, I want to go in there like this. Now, Hilton, fine with me. All right, okay, Mr. Copeland. You ain't gonna try and lock me back up for this, Hilton. So long as you testify, we will get an order to get you released. Bumpus, today? Court, whose copy is this? Hilton, you've got to make sure you come back now. I want to be real clear. You gotta make sure you come back now. I want to be real clear. Mr. Copeland, when have I ever ran? Hilton, you have not. That's the only thing. You have not. All right, Copeland. I'm sorry, the court, Glanville. Whose copy is this? Hilton, that was ours. Do you want a copy? You could take it though. Bumpus, okay. Hilton, do you still have yours or you threw it away? Ms. Bumpus, I'm going to give him both of these things so he can have some information. Ms. Hilton, okay. The court reporter, are we off the record now? The court, are we done? Ms. Bumpus, yes, I believe so. The court, okay, we're good. See everybody downstairs in about 10 minutes. The proceedings concluded at 11:31 a.m. Wow, man. Wow. I hereby certify that the foregoing transcript was taken down and stated in the captions and colloquies, questions, I don't know how to say that word. I'm sorry. Questions and answers were reduced to typewriting under my direction. That the foregoing pages represent a true and correct record of evidence given. I further certify that in accordance with OCGA 9-11-28A, I am not a relative, employee, attorney, or counsel of any party, nor am I financially interested in the action. The first day of July. Yo, this is absolutely insane. What you all think about this, man? Let me know what y'all think in the comments. There's definitely a lot of pressure for sure. Now, the question is pressure necessarily coercion, right? But Glanville, though, this was all dirty. This was all of this was dirty. All of this was just another ploy to get him to testify after he pled the fifth. There should have been a mistrial. He told them on the record that he said to them every single day, I told you that I did not want to testify. Even Melnick said he did not want to testify. Melnick was withdrawing himself because he knew that he could not represent him properly as a witness or represent his testimony without knowing what the state told him. And then he's supposed to believe what the state told him after the fact. Like, it don't work that way. So, yo, like this video, share this video. I know this is kind of long, y'all. I'm sorry, but we had to get the full transcript, the full effect, the full Monty. Yo, hit the subscribe button, hit the like button. We'll be back for more. And trust me, we're going to get back into our sports, but right now we on these other topics real quick. But I'm your boy Tay Biz from Tay Biz TV.